We are in the valedictory function of the Child Rights Week celebration of Kerala State IAP, organized by IAP Kottayam branch. Can you hear me?
Yes.
Can you hear me?
Yeah.
Today I am entrusted with the present duty of welcoming the dignitaries and all the participants to this August function. First of all, let me accord a very warm welcome to our vibrant state president of IAP, Dr. M. Narayanan. Next, I should welcome our national president-elect, Dr. Ramesh Kumar. I take this opportunity to also welcome our national vice president, Dr. Ananda Kesavan, TA. I should also welcome Dr. George F. Mulail, chairperson, ICNCM. With pleasure, I am welcoming State IAP President-elect, Dr. T.P. Jayaraman. Dr. Ashok Kumar P., convener ICNCL, is also welcome. Next, I should welcome Dr. Balayendran D., the active secretary of State IAP. My own treasurer, Gulam, treasurer of IAP Kottayam branch, is also welcome. I take this opportunity to also welcome other senior leaders of State IAP and all my beloved colleagues all over Kerala. Thank you very much. Next, I would like to come before you for a few more sentences regarding the activities that have taken place all these 10 days, right from November 15th to November 25th. As you all know, the program began with the inauguration of our vibrant president, and this was followed by very vibrant programs related to protection of child rights conducted with all these 10 days in a very, very hectic way. I should congratulate State President Dr. Narayanan, Secretary Dr. Balayendran, Dr. George F. Mulail, and Dr. Ashok Kumar for conducting this Child Rights Week celebration with great vision and in a very, very grand way. Hats off to President Dr. Narayanan for conducting all the presidential programs in a very grand and unique style, even with the hindrance of the COVID season, and also implementing many, many useful pediatric webinars within this year. We, the members of Kottayam branch, were extending very good support to our state administration. I should thank or extend my heartfelt gratitude to our beloved and vibrant state president, Dr. M. Narayanan, for giving us this excellent opportunity to conduct the valedictory function of the Child Rights Week celebration. Thank you all very much. Jai IAP.
Thank you, sir.
Thank you very much.
Thank you very much. Now, the presidential address by Dr. N. Narayanan, President IAP Kerala.
Good evening to you all. Respected President Dr. Damodaran sir, National Vice President Dr. Ananda Kesavan, President-elect 2021 Dr. Ramesh Kumar, Dr. George F. Mulail, Dr. T.P. Jayaraman, Dr. Ashok Kumar, Dr. Balajender, and today's speaker, Justice K.T. And my dear IAP Kottayam and IAP Kerala and senior pediatricians. Today we are having the valedictory function of Child Rights Week. Actually, before the COVID started, we were planning to have a large scale conference on child rights organized by Pariyaram during the month of March. We had the first conference for the South Zone at Thiruvananthapuram, but it was in the third week that everything went against our plan in the COVID setting. But fortunately, we were able to overcome the obstacles and organize a number of also during the Child Rights Week. I thank all the branches for contribution to organizing the Child Rights Week programs, which we had 8 programs we had. Today is the 8th session we are having. And also we have been able to publish a book. It will be a handbook for the reference book for the pediatricians. It will be distributed. So we have all the reasons to be happy about in conducting the Child Rights Week celebrations. And to the Pariyaram branch, you have organized this valedictory function with a salute session. Even though a branch with relatively less number of members, we have been able to hold this meeting. And I'm sure a good number of doctors are attending this session. Thank you, Damodar sir, for the kind words you have showered on us. And thank you all the participants for this meeting. Wish you all a happy session ahead. Thank you.
Thank you, sir. Now call Dr. National Vice President, South Zone, Dr. Ananda Keshwan, sir.
I think sir is not there, I think. Yeah.
Oh, is it? Can I move to the next speaker?
Yeah.
Yeah, call upon the President-elect of National IAP, Central IAP, Dr. Ramesh, sir.
Respected President of Host Branch, Dr. Damodaran, State President, Dr. Narayan, South Zone Vice President, Dr. Ananda Keshavan, President-elect for State, Dr. Jayaraman, sir, Secretary, State Secretary, Dr. Balachandran, Secretary of Host Branch, Dr. Ranjit in absentia, Dr. Gulam, Dr. Johnny Sebastian, Secretary-elect, Dr. Sudhayaran, sir, Dr. George Molero, past president and one of the pioneers in this, our child rights, as well as the chief guest of the day, Dr. Justice Nisar Muhammad, and all my friends who are out here to make this a validated function of this Child Rights Week a great success. Good evening, and I'm quite happy that the state IAP could organize. It's maybe a unique, I believe, a Child Rights Week celebrations with 10 activities, and that too on different topics coming up by different branches. You cannot expect anything less from such a vibrant team of Dr. Narayan and Dr. Balachandran, supported by other office bearers and Jairam sir and all in the entire state has been, in fact, a topic or a subject which is not of clinical practice, I believe, but holds so much dear to the pediatricians, especially on our child advocacy, child abuse, POXO, child rights. These are things which our social commitment speaks about. And really, absolutely, IAP Kerala is far, far ahead, because I have been there at the center for 2 years. I know how difficult it is to push through certain this advocacy. All said and done, we talk so much about it, but it's so difficult to get a platform to discuss these issues and to come up with some sort of audience to listen to us and take up the sensitize them. Quite difficult, but Kerala IAP has managed. And congratulations to Pariyaram branch, especially Dr. Damodaran and Ranjit as well as Gulam for taking this up, and hats off to you. And more importantly, Dr. Ashok Kumar, the stalwart of IAP our child rights and our all of such similar activities. Sir has been leading from the front for last so many years. I know, sir, about 15 years he has been spearheading our campaign in child rights, and he has come up with a book also, a wonderful book which I was now only I'm going through that. There's something like from a fearful childhood to a cheerful life. So such a beautiful caption, or some so the team of Dr. Ashokumar, Dr. Mulil, Dr. Bennett, as well as Dr. Newton, he has learned that Newton has contributed a lot, Dr. Suma and Soman, Dr. Narayan. So all have contributed in a big way to that book. So this is something unique coming from any state branch, not even from state. Central IAP, we didn't have a book. I'm not sure whether on child rights. So congratulations to the whole team and the IAP Kerala, especially for all the innovative activities on this front. And today we are having would be exciting session ahead from seasoned veteran in this field. So hopefully this concluding this valedictory will be a befitting sign off for the Child Rights Week celebrations of Kerala IAP. Again, my sincere gratitude to IAP Pariyaram and IAP Kerala for giving the opportunity to be there with you, and congratulating all the team, all members behind this venture. Thank you, Jai IAP. Jai.
Thank you, sir. On behalf of IAP Periyaram, we congratulate you for your president-elect officially on this podium. Thank you, sir. And for felicitation, I call upon Dr. George.
Dr. George F. Mulay. George F. Mulay.
Sir, unmute, sir.
Unmute.
Unmute, sir. Mulay, sir.
Unmute. Please unmute, sir.
Actually, I had muted myself. Okay. Our President of IAP Kerala, Dr. Narayanan, our Chief Speaker of the Day, Sri K.T. Nizar Ahmad, District Judge, Ramesh, all our leaders of IAP Kerala and national leaders, and all those pediatricians who are really interested in the welfare of the children. I'm very happy to see that this is the first time that such a week has been celebrated in Kerala IAP. Actually, it's not week, actually, it's 11 days, starting from 15th to 25th. And we had so many activities, we had so many sessions in various fields of child rights. And I should congratulate all the branches for conducting it. Especially now, today is the turn of Pariyaram under Dr. Damodaran. You have done a very good job today. And I don't know how to describe Narayanan. When any president take over, he will say so many things. But I have seen Narayan had given the importance to child rights on the very day of his inaugural speech when he was installed as the president of IAP Kerala, and he has kept up his promise in spite of the restrictions brought by the COVID. So I should congratulate Narayanan, and Bala also an able lieutenant to Narayanan, because Bala was again really interested in this field, and he was also instrumental in conducting so many programs. And as already mentioned, we had brought out a book on child rights. I don't know how to describe the effort of Dr. Ashok Kumar. Actually, even though I am the chairperson, I will say that 90% of the work was done by Ashok Kumar only, because such a vibrant person from the very beginning, as he entered the activities in IAP Kerala, I know, because he was a person who took over the neonatal insurance program also. Anyhow, wherever he is and whatever work he does, he takes it, he does it with all sincerity. Congrats to Ashok Kumar. Now, what I want to say is that let us keep up the tempo. IAP is one organization which is really interested in the welfare of our children. So let us all join together for our children, fight for them, because now only that importance is being given to children. So let us all join together for our children. Let us fight together for the rights of the children. Thank you, IAP, Jai IAP Kerala.
Thank you, sir. Now, I call upon Dr. Jayaraman, State IAP President-elect 2020.
Good evening, everybody. Am I audible?
Yes, yes,
Yes,
sir.
sure.
Yes. Respected President Dr. M. Narayanan, Dr. Damodaran, President of Pariyaram Branch, Dr. Gulam, Dr. Ranjit in absentia, Dr. Ramesh Kumar, President-elect, Dr. Balachandra, Dr. Joseph Mulil, Dr. Ashok Kumar, and the Chief Guest of the Day, Judge K.T. Nizar, District Assistant Judge. I am very happy to participate in this valedictory function organized by uh, IAP Pariyaram on the towards the end of this Child Rights Week, which is very well conducted by IAP Kerala for the first time in the history of IAP Kerala. And all these deliberations of the last 10 days was very good and covered almost all issues of child rights, and it was attended by a lot of delegates. And this is a wonderful attempt on the part of IAP Child Rights Group and Dr. Ashok Kumar and Dr. George F. Mulay. I congratulate them as well as Dr. Narayanan and Dr. Bala for the wonderful work they are doing, and especially the book which they have brought, which covers almost it is a collection. I think it should be in the collection of all pediatricians in India, which deals with almost all the issues of child rights, which comes in day-to-day practice of every pediatrician. And the ending day, this last day, is marked by one of the most important issue of contemporary relevance, that is the POSCO Act. And you have got a very good speaker for that. I congratulate Pariyaram branch for arranging this session, and I wish the very best for the program. In addition, actually, Dr. Ashok Kumar was talking me about spreading the child rights group to the entire Kerala, and I offer all the help, and I will try my level best to help this child rights group to become a subspecialty during my tenure as president of Kerala IAP. And I offer Ashok Kumar and Joseph Mulay all support for their relentless activities for the last 15 years. Thank you so much for giving me this opportunity to address you on this day, and I wish the very best for this conference. Thank you all once again.
Thank you, sir. And all the blessings for your vision ahead. Next, I called all-rounder of IAP State, Dr. Balchandra.
Thank you. Respected President Pariyaram Branch Dr. Damodaran, our State President Dr. Narayan, our National President-elect Dr. Ramesh Kumar, our I Council officers Mulil sir and Ashok sir, our Chief Guest today, Sri Nisar sir, and our President-elect Jayaraman sir, Dr. Gulam, all seniors of Pariyaram and across the state and country. I'm extremely happy to be part of our presidential action plan on child rights, the first time observed across the country. And we should appreciate the vision of our president of TB-free air for every child. Was well taken up by the state TB still as well as the NTEP. Congratulations, sir, for your vision on both child rights and TB-free air. And both these topics were introduced well in the beginning itself. We had our first TOT on January 30th and our first CME on child rights on March 1st at Trivandrum. And I thank all the branches for the excellent activities, especially during this pandemic. And I thank our office bearers of I Council, Mulay sir and Ashok sir, especially Ashok sir, who has selected all the good, excellent topics as well as the speakers for this last 10 days. We are planning to release the book maybe by December, one book on child rights and other handbook on LTBA. Hopefully we will materialize by December. And as you all know, we have successfully cut down the mortality of mortality due to pneumonia, diarrhea, and malnutrition. And we are on the path of enabling the disabled. And now it is time to prevent abuse in children. And I heard today in the FM today morning that there are 14,000 cases of rape and abuse in our state this year, and of which 5,000 is on children and adolescents. So it is our collective effort to think, learn, and improvise for the betterment of our children. So I congratulate IAP Pariyaram for organizing this event, and I wish this conference all the best. And thank you, Jai Hind, Jai IAP.
Thank you, sir. Shall I go ahead with the vote of thanks?
Yes, please.
Yeah. On behalf of IAP Periyaram, as treasurer, we are very humbled, honored to have this validatory function of Child Rights Week celebration on behalf of State IAP Kerala. I thank our vibrant president, Dr. Narayanan, and our all-rounder Balchandran, and all the other dignitaries who have been with us today. A special thanks to Dr. Damodaran sir, who coordinated this function today. And all thanks to all the webinar team work who have done the basic works to this program today. With these few words, I thank you all once again. I call Dr. Ashok Kumar sir, the convener, ICNLC, for introduction of the next speaker.
Good evening to all. Respected State President Dr. Narayanan, Dr. Damodaran, Dr. Ramesh, other dignitaries. I also recognize the presence of past National President Dr. R.N. Srivastava sir and Professor Dr. V.N. Tripathi from UP and other people from other than this state also, and invited faculty, District Judge Sri Nisara Ahmad, my dear friends and colleagues of IAP Kerala State. I'm extremely happy to be part of this program. In fact, the last 1 week, we are having programs related to child rights. And today, we are ending this with a wonderful session. Child sex abuse is the most serious violation of child rights. Not only it violates the rights of the child, it leaves behind a lifelong sequelae. In 2020, the Indian Parliament has passed a very important act, that the POCSO, Protection of Children Against Sexual Offences Act. It streamlined the offences, punishments, and denote the responsibilities of each and every stakeholders related to this law. The medical professionals have the primary responsibility for identifying sexual abuses and treating the children with whatever problems they have. Along with that, they have the responsibility of documenting the evidences, and they have to report the case in the appropriate authorities. That is the specific mandatory clause given in the POCSO Act. If you have not reporting to the appropriate agencies, you are punishable under the Act. And there are a few incidents of cases registered against the doctors for not reporting. Fortunately, I think there was no severe punishment given so far. I think the speaker will be enlightening us on that part. In the POCSO cases, our responsibility is to help the judiciary as well as the police to give justice to the victim and punish the culprit. And the history and evidences collected by the doctor may be counterproductive if it is not done meticulously and done in appropriate way. The judiciary and the law expect a sincere effort from the doctors to follow the proposed guidelines and principles when you do a medical examination. What are the expectations from the doctors? What are the pitfalls occurs in such cases, and how can we perform our responsibilities correctly? To enlighten us on this topic, we have an eminent person from the judiciary, Sri Nisar Ahmad. He is district judge and member secretary of the Kerala Legal Service Society, Kerala High Court. Sri Nisar Ahmad, hailing from Kottayam, Kozhikode, started his career as an advocate in Kozhikode. Later joined the judicial services in 1997. He served as in various positions as municip magistrate, additional sessions judge, additional judge, and additional sessions judge. And he has a long experience of working in the special court for women and children. And he has worked in almost all the districts in Kerala. At present, he is deputed as the member secretary of Kerala Legal Service Authority, High Court, Kerala. With these words, now I welcome you, sir, to give your presentation on the responsibilities of medical professionals in POCSO, according to the POCSO Act. Over to you, Mr. Sir.
Am I audible now?
Yeah.
Okay. Respected senior doctor friends of Kerala and even outside state, a very good evening for all of you. First of all, I would like to inform you that I'm very much happy to attend this program on two grounds. First one, being a judge or was a judge for Special Court for Women and Children in Ernakulam for 3 years, I had suffered a lot. Just like doctors, I think I can say that is something more than that. Sitting in a children's court, especially this POCSO court, it is highly traumatizing. And now I got an opportunity to share my experiences to the doctors. Previously, I had a discussion with doctors at Ernakulam General Hospital. There was a conference of doctors, and I had taken a class in 2018. I think it was 2018 May. And the second reason is that my eldest brother is a pediatrician, Dr. K.T. Salim. He is now working in Dubai, Aster. And when I informed him that I am going to take a class for those pediatricians in Kerala, he just informed that he is also a member of your association. So that is the second reason for my happiness. I can take a class for an association members in which my elder brother is also a member. Today, your validity session, that is the last day, Ashok Kumar has said in the beginning itself, there was 8 programs as for last 1 week. I know that you're all fed up, so that I can wind up at the earliest. Now it is 8:30, and it is not possible to elaborate on all the aspects of POCSO Act with a short period. Of course, it is a small act with a few sections, 46 sections. But when you start to discuss with each and every sections, it will take time. And I know that most of you are not interested in this subject, not because of your earnestness, your responsibilities or some other, but because of the subject is such a nature. And apart from that, I would like to say the word from the experience from the court for the 3 years in the Ernakulam Special Court. The doctors are even afraid of this POCSO Act. I'm using this word afraid because there is a feeling that some of the provisions of the POCSO Act is causing much difficulty to the medical professionals. Dr. Ashok Kumar has mentioned in his speech that there was some instances of conviction of doctors. The first one, conviction in Kerala of doctor in a POCSO case, that is in section 1921, that is non-reporting. Unfortunately, it was from my side, but as said Ashok Kumar, I did not sentence the doctor. I only found her guilty and convicted, but she was admonished. Hereafter, don't fail to report. Whenever you get knowledge about any commission of any POCSO Act, report the same as per the provisions of the Act. I did not sentence. But at the same time, I had the opportunity to free, rather discharge, even without trial, a doctor, which according to me, he was unnecessarily made as an accused in that case. I start with that incident that I think would be good information for you. 2 Parda Nation ladies, Muslims, you know, came to a doctor in a hospital at 11 p.m. night. Introduced that mother and daughter. The daughter was complaining stomach pain. Doctor has given some medicine. Within few minutes of taking that medicine, this daughter, lady, has delivered in the toilet of the hospital. They never disclosed the fact of pregnancy to the doctor. Only when this incident happened, that delivery occurred in the toilet, it was came to the knowledge of the doctors and the hospital officials that she was pregnant. Of course, in the very next day morning at 10:30, from the hospital, intimation has gone to the police. Police has registered a case also. But I don't know the reason, but this doctor was made as an accused, co-accused, under section 19(1) verse 21 of the POCSO Act. For the reason that he did not inform the police at that time, that is at 11 p.m. night. But I'm of the opinion that going by the POCSO Act, that is not the intention of the legislature. Of course, there is a duty cast upon everyone, not only the doctors, that includes we the judges. Nobody is exempt. If anybody comes in, gets knowledge or apprehension of chance of committing any POCSO or having committed a POCSO offense, has to report the incident to the police. But that doctor was made as an accused because he did not, or he rather failed to inform at midnight. By written in my judgment, that is not the intention of the legislature. Of course, going by the act, so if the doctor gets the information, doctor has to give information to the police. That does not mean that doctor himself has got to the police station and give that such and such has happened. Doctor can depute. In the case of hospital, there will be a PRO or some other officials to communicate with the police station. In that particular hospital, the doctor, hospital authorities have given intimation and police has already registered the crime. There I discharge the doctor even without trial by writing the reason that this is a mere misuse of the provisions of 1921 of the POCSO Act. I had two opportunities to take classes against police officers. I repeatedly stressed and informed them and advised them not to use this provision without applying your mind. This provision is intended with a good objective, with a good intention. As you all know, even an educated people, even an incident happened, if offense coming under POCSO Act happens in my family, my first response will be the suppression. Even though I'm a judge I had the experience of sitting in the POCSO special court, my first response will be suppression, will not be reporting. That will be this most of the cases in the doctors and everybody, in the educated person. That is because of our society. Our society, we are not so much developed to give immediate report of such crime. We are taking this type of offenses as a shame. Better suppress because of several reasons. So this provision is meant because in the case of children, nobody will report. Even the parents will not report. The children normally, they may not be knowing even that offenses will commit. It's an offense, it's a crime, or it affects their health or adversely affect the child. The parents will not report. The third parties may think that why should we interfere in their affair if they are not interested? So generally we can see that in the case of a sexual offense committed against children, nobody will report. So the legislature in its wisdom has incorporated such a provision that making it mandatory, and provision is made for punishment for non-reporting. That is with the intention of reporting maximum number of cases so that we can collectively at least reduce such incidents in future. And I already told you that in cases for the 3 years while I was working as a special court, I can see that only the doctors and teachers were made as accused under section 19 or 21. It has got a special reason. because the doctors and teachers are getting the primary information, or rather very authentic information. Normally, in such incidents, I think the family will go to the family doctor. And in the case of children of schools, they speak or inform this incident to their teacher. So that is the reason I have not seen any other person made an accused under section 19/21 in POCSO code, except the doctors and the teachers. I have mentioned that I had convicted the one doctor, that is first conviction of doctor in Kerala in POCSO. There, I was convinced the doctor was aware that such a provision is there, doctor is bound to report. But what happened was that helpless mother requested the doctor not to report because it will tell upon or the carrier of that or even the future of this girl. So normally the doctor, any doctor, even I don't even, I was in that position of that doctor, I would have not have reported. But that is the position, and then we have, so that understanding that position, you know that there is a provision, there is a special Probation Offenders Act. Court can apply the Probation Offenders Act and admonish the accused and release him without any sentence. So such instances may happen because of the request from the parents or the family members. The doctors may put in a dilemma and they may not report. And there is the contra situation also. There are instances the doctors requesting the family, the parents, not to report by saying that the doctor will be dragged to the court. There was such an incident. But there are even doctors with full of commitment in mortal, even before this POCSO Act. I had tried one case in Ernakulam where a small child was brought to a private hospital. It's full of injury. I think the child is 2 years old, something. Full of injuries. And the child was brought to the hospital by grandfather. And what the doctors, the history stated was, the doctor fall from a table, something like that. Doctor got suspicious because the injuries, this much of injury is not possible for a single fall. Doctor has intimated the police. Police have investigated and found that this grandfather has brutally assaulted physically this 2-year-old boy because he's very naughty and this child's parents are abroad. His parents entrusted this child to his grandfather. And he happened to talk in such a way. And there, I could not sentence the same person as the doctor. I found him guilty. I found the grandfather guilty of assaulting this small boy of 2 years. But I'm not in a position to provide the sentence because that child is still in the custody of that father. That parents still in abroad. Suppose I put that grandfather in prison, who will take care of this child? So the mind I applied this Probation Offenders Act in that case, and I did not sentence. So there are doctors, I can say that more than 90% doctors are fully committed and fully showing the responsibility and having the social responsibility and social commitment. I worked as a magistrate for 12.5 years, and now it is 24th year of judicial service. I had examined lots of doctors. So I know the commitment from the side of the doctors in certain cases. But of course, in every profession, including there will be black sheep, some more. But normally, I can say that most of the doctors are very committed, especially in POCSO cases. I don't know whether any of you have appeared before me in my court while I was in Ernakulam. And with these few words, I'm going to enter into the topic. Of course, we have already entered with starting with this 19.1 to 21 of the POXO Act. I'm not elaborating on the each and every aspects of POXO Act. I can just give an outline. This act came into force on 14/11/2012, November 14, 2012. Going by this act, section 2, a child means any person below 18 years. The crucial important aspect is that there is no difference between girl child or boy child. The act says only child. The word used is child. That is, the act is gender neutral. As you know, the case of rape commit can be only against women. Here, the legislature has avoided that word rape and used the word penetrative sexual assault. That is because this offense can be committed even against boy child. So as far as POXO Act is concerned, any person below 18 years is a child, and it will come under the POXO Act. So in every case, the first and foremost aspect to be proved before the court of law is that the victim or the child involved in this case is below 18 years. And the definition part, the important definition is regarding the child. And of course, this penetrative sexual assault that you might have heard of, you might have attended several classes. I'm not going to enter into that. But there is a subsection 2 of section 2, subsection 2. That has some importance because there it says words and expressions not defined in this act will get the definition or the meaning assigned to the Indian Penal Code, Criminal Procedure Code, Juvenile Justice Act, and Information Technology Act. So whenever you study this act, when you want to know the meaning of a particular word, you have to go to the definition clause. That's section 2. There's only few definitions. We cannot get to the definition of several words. So for which we have to these particular acts, IPC, CRPC, JJ Act, and Information Technology Act, etc. It has great importance because, as I already told you, that this is a general neutral act. This act is applicable, that is, even to the ladies. I'm stressing because you cannot find a lady guilty for rape under section 370 of IPC. There can be only the male. We can allege rape only against a male. A male can commit rape. But in the case of POXO, both ladies and gents are included because it is not general neutral. So whenever you read section 3, the section 3 to 15 deals with the offenses. Section 3 is that the word used is he. He normally we will get, he means male person. But that he includes she also, for which we have to refer Indian Penal Code. So even for an offense under section 3A of the POXO Act, that is penetrative sexual assault, you can prosecute or found guilty or convict lady. So going by that definition of section 3, you can see that the party need not be the active participant. Suppose a lady causing a child to penetrate his penis into the vagina of that lady, she will be liable under section 3A, that penetrative sexual assault. So, but when you read section 3, we may have an impression that it applies only to the male, but it actually applies to women also. The other type of ones, this penetrative sexual assault aggravates in the case of certain number of certain persons because of their official position or otherwise, or certain circumstances, or the consequences on the child. That is covered by section 5. That aggravates, and definitely that offense is very severe. I'm not elaborating each and every area. It is not possible also in this short period of time. Then comes comparatively lesser offense, sexual assault. That is not any just touching the breast or the sexual organs of the child, or any physical contact other than sexual penetration. Here also it aggravates when it was committed by certain categories of persons that because of the circumstances or in the case of the consequences on the child. Then comes the sexual harassment, comparatively lesser, you may say that lesser light offense, section 11. But in my view, section 11 offense, that is sexual harassment, is the most committed or most incidents committed against the children. I think 90% of the children will be subjected to sexual harassment. This we can see while sitting in a court of special court for POCSO offenses. Yes.
Excellent talk.
Yeah. That we can see. We may have a feeling that most of these crimes are committed against girls. Actually, the statistics shows that more boys are victims of this crime. If a boy goes out of the house for going to school, so you have to either take a school van or an auto or a bus, or you can walk to the near road. I can say that at least from that school van driver, or the person responsible for the school van, or the auto driver, or the nearby one while passing the road, there will be at least some person at least making a comments that even the boys as well as girls. And suppose that girl happens to go to a nearby shop, that shop owner will at least catch the hands or some part of the body. I'm telling this because for that 3 years while sitting in that court, I had convicted all these types of men. I had convicted, I use the word doctor, I had convicted engineer, I have convicted lawyer, I had convicted policeman, I had convicted priest of the church, temple, and even the mosque. Nobody, there is no exception. In the case of atrocities against children, nobody is exempt. If I'm going to take all these cases, it will take days to explain all those things. Anyway, I will give some one or two instances that may be interesting for you. A priest of a temple of a particular place has taken a boy from that place and brought to Chotanigara. This priest was approached by the family of this child because of there's some problem. Somebody told that this priest is give some advice and your problem will be over. That poor family came to this priest. The priest told the family that such and such, your family is having such and such problem. You have to go to Chotanigara temple and do some rituals there. And the priest again mentioned that I know that we are very poor, you may not be able to come to that place. And the most affected person is that boy. You send that boy to be along with me. I will take him to the temple and do all the rituals and go back. That poor family sent that boy along with this priest. He had taken all along from a district. I don't want to mention that district in northern side and brought to Chattanooga. And in a lodge, he had sexually assaulted that boy. When he refused, the priest told the boy that if you are not cooperating, the Chattanooga Devi will curse you. So, at the name of the Chattanooga Devi, that man has assaulted that boy. That is clear evidence that I found him guilty and convicted and sentence given the maximum of the life imprisonment. While I convicting, I told him that this conviction is not from the sentence is not from the court. You had abused this boy, poor boy, in the name of Devi. Probably Devi might have given this sentence. I have told that fellow. And another priest, then it is not fair to mention only priest of a temple, I can tell you that, and the priest of a church. I did almost the same thing with a girl, and he had been convicted. I had given the 12 life imprisonment, two life imprisonment in 2 different sections. In that case, I had convicted the doctor also. And in another case, a madrasa teacher had abused the girl by saying that there will be attack of a ghost. It is very easy for Muslim girls and boys to say that Pishaj, you know that ചെകുത്താൻ്റെ അക്രമം ഉണ്ടാകും സഹകരിച്ചില്ലെങ്കിൽ എന്ന് പറഞ്ഞ് ഉപദ്രവിച്ചു. So you can see that every person, human beings, every walks of life, nobody is exempt. All are getting, even get a chance to assault or child, it will happen. And at the beginning, when I started taking cases of that court, I was also of the opinion, when case comes, is it possible? How can it, is it believable? Is it true? But now I can say that any type of offense, any manner, the children can be abused in our society. Every type, from any place. Of course, you know that there are several instances of incest and other offenses by the parents, even the father itself. Even this COVID period, as you all know now, I am the member secretary of Kerala State Legal Service Authority. Going by the statute, there is a role to be played by Legal Service Authority in the POCSO Act, that is giving legal aid to the victims and also the compensation aspect. Even this, during this COVID period, I had to approach the Honorable High Court to get orders for MTP in 4 cases. Even yesterday, I had to file a case for getting permission to do MTP for a 13 years girl is carrying now 20 weeks. And the accused is none other than her own father. In one case, I convicted a father having committed rape of penetrative sexual assault, all the 3 daughters, you can imagine. And one case that is very interesting, that you may be interesting you also, because the way the cases are being reported, I do believe in God. And I can say that if we fail to report, if the doctors fail to report, if the lawyers fail to report, even the parents fail to report, if the judges fails, there is one who is watching everything. When there is an assault against a child, definitely he will be booked today or tomorrow by this Almighty. I believe in God from the experience I got from that 3 years in that court. I will give some example, you can imagine. A girl, while sitting in the classroom, caused self-inflicting injury on her palm by using a compass. It was seen by a classmate and asked, "What are you doing? Are you crazy?" She politely answered, "You see, when I go home, the mother compel me to do all works in my house. I have to wash the utensils, wash the clothes, prepare food. If I injury is there in the palm, I can escape from the job. A very good explanation everybody will accept. After few days, there was an awareness class in that school. The class was going on only when this girl realized the real consequence of the real incident. She could not control her emotion and she cried. It was noticed by the teacher. The teacher counseled her. It revealed that her own father had sexual intercourse for the last 3 years. This is a true fact. You may think that there may be cases, false allegation will be there, and some allegation may be there, some may not be proved. Some the court believes wrongly, some wrong conviction may be there. This is a true case because that useless, that accused has confessed before me that he did it while under intoxication. So the way it is going to, the case is being reported. Another incident, a girl happened to lift the skirt of her friend in the classroom. That girl has reported this matter to the teacher. Sir, this student is doing this thing. The teacher counseled her, and it was revealed that that girl was being sexually assaulted by a neighbor. And there was another incident, a karate teacher. You may be knowing there was a program in the program of the education department, women empowerment. It is giving karate training for the women, students of the school, ladies, especially ladies. This karate teacher, after completing the regular class, has offered a special class for the special students and requested them to come a little bit early in the morning. And he started. But these poor girls, maybe because of ignorance, or maybe they also finds happiness in that activities. He has abused them, but nobody, it will not, it was gone unreported. But one day, one of the girl who is not in good terms with the other happened to write a letter and put the complaint box in the school, child line box is there. And accordingly that was reported, and this man was booked. So there is, I think there is an inbuilt mechanism that is, even before, without this law, even this section 19, the God has made some provision for the protection children, at least in this way. So even if we fail to report, it will be reported tomorrow. If not today, then it will be tomorrow. Of course, there's sometimes there may be delay alone. So this is the way of reporting. And as far as doctors are concerned, I have already told you that, and doctors and teachers, they are getting the primary information, and in much more cases it is authentic. So you have got a responsibility to report. There will be pressure and dilemma, and there will be a request from the side of family and the school teachers and all the sides not to report and several other grounds. But unless you report, of course, there is penal provision is there, and every court, there may not be a judge, Nisar Ahmed. There will be conviction, there will be sentence, and one judge may be different from another judge, one doctor is different from another doctor, one teacher is different from another teacher. So we cannot expect leniency in every court. So it is the first and foremost request from the side of myself to you all is that whenever you get information regarding a sexual assault against children, report it. When you get authentic information, And the section 19 says every gets knowledge. That knowledge has been interpreted by the high courts. And in the case of doctors and teachers, that will come in that the word knowledge, because you will get primary information is authentic information, unlike other spectators and other neighbors and all. So that is the reason why you, the doctors and teachers, are made accused in these POCSO cases. That much I would like to say about reporting. The second thing, the most important aspect is medical examination. And you're all senior doctors. I can see almost all far senior than me, or experience that you know how to examine. It's an idea notes. But the section says certain things. The law says certain things to be done in such a manner, in a certain manner. In the case of children, the first and foremost thing, whenever you are examining a child, when there is an allegation of sexual assault or like that, the first thing you have to do is to get the consent of the parent. That is mandatory. If you are not getting the consent of the parent, you are committing a crime. You will be liable just like any other person. Of course, there is a special portion, section 41. Now the act says that medical examination and treatment, if done with the consent of the parent, do not come under section 3 to 15 of the act. But if it was done without the consent, there is no difference whether you are a doctor or a... So first and foremost aspect, getting consent. Here, the law itself says that you have to examine the child in the presence of parents, or on a person in whom the child has trust or confidence, or in the absence, a person, a woman, the word used is woman in the act is a woman, nominated by the head of the institution. So whenever there is a child is brought before you with any sort of allegation regarding this POCSO, there is chance of allegation also, but we insist examine in the presence of the parents, or in the absence of parents, in the presence of woman nominated by the head of the institution. And you have to get the consent of the parent. Better you get the consent, that is writing in the once that you are going to prepare the report. And as far as possible, if the child is capable of giving consent, that is understanding things, not so small, get her consent also, get the signature is I consent. That is being safer side. First and aspect is to get consent. So there may be instances in which the accused is none other than the parent, even the mother, maybe things up to. Initially, the allegation may be against somebody else. I had tried case. In this moment, I would like to inform you all that, of course, there is criticism that this act is being misused. There is widespread misuse of this POCSO Act. But you cannot point out a single law in the land without the vice of misuse. Even the IPC is misused. But I would like to say that it is not misuse, it is using the provisions of the POCSO Act. There was one case in which I tried the lover of that girl. The girl's case was that this lover has did this sexual assault against that girl, and trial was everything over. But this poor accused, actually he was not the culprit. The real culprit was the stepfather of that girl. that he could establish before the court by proving this fact by showing the letter written by the girl and the messages sent by the girl lover in his mobile phone, and that either I acquitted that person. That is the only case I can say that the allegation was false. So 99.9% of cases in my division, which I am saying a basis on the contested case, not on the settled or hostile cases, but when the case is contested, 99.9 cases are true. There is a case of an 86-year-old man. You cannot imagine. 86-year-old man has sexually assaulted an 8-year-old girl. This man was brought to the court by two persons by hanging on the two shoulders. You can imagine a person of 86-year-old man assaulting a girl child of 8 years old. And the most pathetic aspect is that when this girl was examined before the court, she told me that she has got a brother and she has got a grandmother. Both parents no more, and she and brother living along with grandmother. So this incident was happened when the grandmother has gone out of the house for purchasing something, and this 86-year-old man is immediate neighbor. He came to the residence and asked for water and sexually assaulted. I asked, where was your brother at that time? She said that he was chained inside the other room because he was mentally ill. So you can imagine. That is why I told in the beginning that I suffered a lot that 3 years sitting as special court for women and children in Ernakulam. It has definitely affected me physically as well as mentally. I had to consult a psychiatrist. You know, because of depression and other, I have got several illnesses from that sitting in the 3 years. That is it. You will be getting only few cases, but my duty daily in the special court starts with this. 24 hours I'm thinking about this POXO offenses and these children's. In every case, when I examine a child, at one point of time, the child will cry. Speaker, they cannot control the emotion. Even though we take all these precautions, the statute provides that there is no chief examination, there is no cross-examination, there is no re-examination. Everything done by the judge himself. The counsel, the lawyer cannot question the lady directly. Even the prosecutor cannot put the question directly to the witness.
What are you to put on mute?
Put by the judge to the witness. The lawyer has to pass the question to the judge. The judge has to mold the question as to see that it causes less discomfort to the child. So we'll be molding the question. Even then, at one point of time, in every case, the child will cry. In one instance, I had examined a child of about 5 years by sitting the child on the lap of the mother. You can imagine both mother and child inside the witness box. Child sitting in the mother's lap. And that too only third day. The first day the child was not responding. I arranged for counseling. Again, another day he was again she was not responding to any question. Again given counseling. Only on the third time she could speak. And this aspect I mentioned because the Act says there should be a child-friendly atmosphere in the court. The Act says only child-friendly atmosphere. The court to do this thing. Court does not allow the lawyer to ask such question. Don't harass the child, and don't call the child repeatedly, etc., etc. But I think not only the court, but also all the stakeholders, the doctors, there should be a child-friendly approach from the side of the doctors. child-friendly approach from the police. This child-friendly means a conduct by considering the tender age of the child. And I used to start the examine the witness in the court, first creating my rapport. My first suggestion will be that to sing a song in the court. So it should be getting, the children will be get relaxed. And I used to carry one toffee in my pocket. I used to give that toffee to the child and request her to sing a song. And I asked then, and I start to ask about her family, parents and hobbies, etc. And that way creating a rapport. This approach should be there from all the stakeholders, not only the policemen, the doctors, and and other officers connected with this also. One incident, a girl of I think it is just 3 years old, something, just speaking something like that. And I brought her close to my seat in the dais of the court, not from the witness box. I requested her to sing a song. Of course, she started singing. And I gave a trophy. And the table, there was another trophy. She says that, may I sing another song? Why she wants the second trophy also. So this approach is necessary in the case of child victims. And this approach should be there from the side of the doctors also while examining them. So medical examination is going by the act. One may have a feeling that for every offense of the POCSO Act, there should be medical examination. But I am of a different opinion. The medical examination requires only in the case where the examination serves any purpose. But in the case of sexual harassment, section 11 to 12 of the POCSO Act, this uttering words, showing obscene objects, and same gestures, doing comments, etc. There is no necessity to examine the child. I had opportunities such even that case. Even in that case, this poor girl was brought to the doctors and harassing even this unnecessarily causing disturbance to the doctors. As far as section 11 or 12, there is no question of medical examination at all, I think, for the purpose of this case. Even in the case of section 7, that is sexual assault, section 7 to 8 comes. There was instances of vaginal examination when there is only allegation of a catching of the breast. So you have to see what is the allegation. The child says that that man has caught my breast. That is the only allegation. Why should we examine the vagina? Of course, it is required in the case of small kids. They could not explain what actually happened. In such cases, there may be instance necessary. But when a girl having the capacity to speak and give something to give the exact details of the incident, and she says, or he says that only the sexual assault in such and such part, there is absolutely no necessity to do a vaginal examination. And you all know vaginal examination is the most traumatic as far as a child is concerned. In most of the cases, that may be the first time the doctor examined that part. There was case the child refusing to examine. Well, it was not necessary also. So medical examination depends upon the allegation, the history. So you have to ask the child what happened. And these guidelines, there is a guideline, detailed guideline issued by the state government in 2015, POXO guidelines 2015. But unfortunately, that is not given much publicity. I can confess you that even after sitting in that special court for 3 years, I didn't see that guidelines. Only when now I sitting in Kerala State Legal Service Authority, there was a case came before the court. The judge has called me and said that there is such, have you seen this? This is a guideline issued by the government 2015. Only that time I've seen that a guidelines is there. Even the department is not aware of this. It's a very strange thing. I contacted the Social Justice Department, but they were in search of this. When I contacted, they were in search of these guidelines. But that is very exhaustive. That everything was covered in very 75 pages of the 2015 guidelines. There it has clearly mentioned the role of medical professionals. It is every detail is there by taking the provisions of the POXO Act and all the APC, CRPs and everything. Everything is there, very evident. It's a lengthy 75 page. And so that is the situation in the case of even the department responsible for implementing the provisions of the POXO Act. This child-friendly approach, the another important aspect there, when you get the important aspect is that when you record the history, you have to record the history as spoken by the child in her own words. The child not be giving the right name for it. So you can write in that way itself. Usually their breast usually be the mamam. You just write ende mamathana, and usually the child says ende അല്ലെങ്കിൽ എൻ്റെ മൂത്രം ഒഴിക്കുന്ന ഭാഗത്ത് തൊട്ടു എന്ന്. അത് if the child says mamam, you can ask, you mean this portion is the breast? Yes, of course, you can just write in that way. This is required even if taking at the time of evidence. The section says even if I take the presiding officer or judge take the evidence, or the magistrate recording the statement of the victim, is we are bound to record in the words of that victim itself. It has great importance. And if the child is not capable of, or his faculties are not developed as much to give us a statement, and if you are taking the statement of the bystander or the parent, you just clearly mention that the history as stated by the so-and-so, so-and-so. This is very important because just I mentioned the case, the MTP, I just filed case day before yesterday for the MTP. Going by the FIR, the allegation is against an innocent boy. You can see. But now it is revealed that the real culprit is none other than the grandfather. So allegation stated in the FIR is that so-and-so child has molested the child. And probably when examined by the doctor, that should have been stated by the child, maybe due to the pressure. Sometimes the statement might have been given by the father himself. So if you take the statement of the child, and if you're having any suspicion, get her own statement. You can request. Of course, the statute says that a victim can be examined only in the presence of the parents. In the absence of the parents, a person in whom the child has trust or confidence. In the absence of such a person also, as I told you, that a woman nominated by the head of the institution. But there may be instances where this father himself may be the culprit. That you can get from this child when the father is separate. You have to do it. You have to take a proactive role at the time. You need not be afraid. You are not doing any favor to anybody. You are doing your duty towards the, I may say that towards the child as a doctor. And regarding the collection of evidence and other details, I need not go to the details of the medical examination that you all talking. And when you are giving evidence, now you are coming to the part of the giving evidence. There was an instance, a doctor in a section 304, a sexual penetrative sexual assault case, came to the witness box. Yes, I told, yes, start. The doctor was simply sitting mum for a quite long time. And I asked what happened. And the prosecutor said that she could not read the allegation written in the medical certificate, not because it is not decipherable, because the entire allegation is so obscene, so sexual vulgarities. So the doctor could not even read it. So I told that here is a shameless person. As a judge of the POXO court, he become gradually everything goes. ഒരു നാണം ഇല്ലാത്തവനായി മാറുന്നു. ഞാൻ പറഞ്ഞു ഒരു നാണവും മാനില്ലാത്ത ഒരുത്തനോട് ഞാൻ വായിച്ചോ. It is so, can say, sexual perversion. So that is what here gets some importance, because the statute that the trial of POXO offense only in camera. You know, in camera, only the limited number of persons will be there in the court hall. You doctors can also for in-camera trial. A normal case may not be necessary, but there may be instances of such a obscene allegation. Even if because of our shame, we may not be able to depose or read the allegation in the open court. You can insist in camera, because statute says tried only in camera. But what the courts now doing is that only at the time of examining the victim, there will be in camera. But examining all other witnesses, I also did the same thing, because a number of cases are there. Conducting in-camera proceeding is that you have to send all the others to send outside. There will not be any facility for inside. The infrastructure will be limited. You doctors may be knowing, and sometimes this in-camera proceedings may prolong for hours. The other parties have to wait outside. So only in the case of now the courts following in-camera proceeding only for at the time of examining the victim alone. But you doctors can also insist in such cases, exceptional cases, that I want in-camera proceedings, because it works. The court will arrange everything. It will be convenient. That is regarding in-camera proceedings. And I think I can now stop my lecture, and you people can ask questions. I hope that better. You people can ask questions. I hope that I can answer almost all of your questions. Okay, Ashok Kumar.
Thank you, Nisar sir. I appreciate your effort in the 3 years when you are in the POXO court, and the emotion you has to face.
Yeah.
This is something I wanted to convey to my own colleagues also. When you have to know, even in the history of sexual abuses, if that feeling is there in the doctors also, we can do a good job.
Yes.
We can give protection to the children. We have a couple of questions in the chat box. I will ask that first, sir.
Okay.
No, there is one question that see, if a parent doesn't report or say, for example, if the child is abused, and
Yes.
if the parents are not reporting, is there
Yes.
any provision for punishing the parents? Is there anything, or is there something we have to do?
Section 19 applies even to parents.
Yeah.
Nobody is exempted. But the problem is that if the parent is made an accused, in most of the cases, there will not be any, there will not be witness. So parent will be a witness in that case. the police in a dilemma. If the parent is made an accused, the parent cannot give evidence as a witness. That may be the reason for not prosecuting the parent for under section 19 to 21. Going by the statute, nobody is exempted. There is no observation from anybody. There was a argument or a argument to the effect that in the case of confidentiality, there is a lawyer-client communication, and in the case of psychologists and giving counselors counseling, there is some confidentiality. They are not supposed to speak to others. But this enactment, section 42A of this act, has overriding effect of all the existing laws. 42A of the POCSO Act. So when there is a conflict between any provisions of the any other act and the provisions of this POCSO Act, the provisions of this act will prevail over it. So going by section 42A, even that privileged communications case itself, even so lawyers, like counselors, etc., they are bound to report, they are liable under section 19. Because here the victims, you know that I always told the children, unless we report, we take a case that this is not my, there is no difference between my child and your child. Here the child belongs to this country, the state has to protect this interest. So that's why such a provision is brought. Nobody is exempted.
Okay. Can I ask you, I add one thing?
Yes.
Suppose the parent himself may be a co-defendant. So that means he doesn't have to report against himself.
Yes. There is already, so actually is, as per the question of the doctor, is an accused in that case.
Yeah. No,
there's 19 applies because 19 has no relevance in that case because 19 to 21 gives only punishment of 6 months, a maximum 6 months. But if the father is the accused in this first penetrative sexual assault, the punishment is life imprisonment till death. And in now, suppose the child is below 12 years, even the capital punishment is. So you know this POCSO Act has been amended in 2019.
19, yeah.
And even the capital punishment can be given. So the relevance of section 19 goes in such instance. That is why section 9 is not added. So he's going to get the maximum. Why should these 6 months?
And you cannot compel a person to give evidence against himself.
Yes.
That protection is also there.
There is another question whether they are.
That I just answer the George Mule.
Okay, fine.
Very important question. There is 2 provisions in this act. That is, according to me, that is the backbone of this act. That's section 29 and 30 of the POCSO Act. That's 2 presumptions. Section 29 gives a presumption that whenever there is a prosecution, the court has to presume that that man has committed that offense. One thing. And section 30 says, in a case where the intention, knowledge, motive, etc. is relevant, the court has to presume that that person had that motive, knowledge, intention, etc. That is attributed. The relevance, the question of relevance comes in the case of 29, as you all know, in a criminal case, the entire burden is on the prosecution to prove the case beyond reasonable doubt. The prosecution has to give the best evidence before the court and to convince the court all beyond reasonable doubt. But in the case of defense case, suppose accused is giving a defense case, the rigor of proof is very, very less than the prosecution. So accused need to create only a shadow of doubt on the prosecution case. Then he's entitled for an acquittal. But in the case of section 30, there is a difference. Section 30 says the rigor of proof in the case of section 30 is equal to that of the prosecution. That means the defense has to prove the case beyond reasonable doubt. That can be done only by entering this accused in the witness box. I will give you an example. It is very interesting when the question is very relevant that you are answering. A teacher, while taking class to the students of 10th standard, there were about 150 students, and he happened to show some pictures by using his laptop. But instead of intended folder, he happened to open a folder containing pawns. You know what happened then. And this teacher, of course, everybody knows that he had no intention. Of course, his laptop was having the porn videos, but by mistake, he happened to open that folder, and that obscene pictures and everything came in the picture, and they happened to be seen by the children. Here, he has committed an offense under section 11, read with 12. Of course, section 11 starts word whoever with the intention of. Here we know that that teacher has no intention to show this obscene picture. But the law says, section 30 says, the court has to presume that he did with that intention. Then that this teacher can prove only by entering in the witness box and say that it is true that I had shown the obscene pictures of the children, but it was not with intention, it was by mistake. If he happens to enter in the witness box and admits this fact, and of course we can accept that explanation, he may escape from the POXO Act, but he will definitely liable under section 292 and 293 of the IPC. So he has no other go. Teacher expelled, lost his service and everything. And that is situation. That is in an incident where a teacher happened to be an accused in the POXO case. There, this question. So you all know that nobody can be compelled to be a witness against himself. That is why the relevance of that doctrine, section 23, article 23 of the Constitution. That is a constitutional guarantee. Nobody can be compelled to be a witness against himself. Here, we can say up to a certain extent that we are compelling this accused to give evidence against himself because he has to admit before the court that I did it, but it was without intention. So the doctor's questions get relevance. There is a challenge of this provision section 30 in the High Court that is pending, not decided so far, since it is violative of Article 23 of the Constitution. Okay, next question comes.
There is a question whether it is written consent is necessary. I think it is self-explanatory. You need a written consent.
Nowhere it is stated that, but in the procedure, I think the guidelines, everything it is written. You get it written consent, because to say on even if there is no provision, I think I can say what I understand that is better you get the written consent as far as possible to consent of the child also. It is because there may be instances of like this child probably the father may be bringing the child before the doctor. Later the father himself will be the accused and you may not be known. So get the consent of the consent written form. I do consent and get signature also. As far as possible, get the consent of the child also. That is better. So they may change. There is no guarantee. A child can be easily swayed away. You know that. So better get a written consent itself.
This one question is about the offender, the accused of in a sexual offense can be a habitual offender.
Yes.
On repeating the crime,
yes.
What is the provision to prevent repeated crime? What is the provision?
For repeated offenders, there is special provision in the Act itself. Not only in the POXO, so not in the case of girl child, IPC offense also there is a specific provision. Punishment is very grave. You won't be released in the once a man has been repeatedly sexual assaulted. That is repeated incident. You may repeated conviction. I may say a convict having got a conviction in any of the sexual offenses previously. Second, committing any of the offense under the POXO. or even the IPC offense section 376, etc., then he will not see the light. He will be there in the prison for life. You know, the life imprisonment, the present. There are two types of life imprisonment. Generally, life imprisonment means life imprisonment the remaining life of that person. But you people know that after 14 years, government has got the power to commute then release him. But after the amendment of the 2013 in the IPC, they brought the government legislature has brought life imprisonment till natural death of the person.
Towards the end. Yeah.
Now, originally it was not there in the POXO Act, but that was brought to the POXO Act also in the recent 2019 amendment. So in such case, I can say that 100% he will not see the light thereafter. He will be there, no parole, no commutation, something like. I can say that I had sentenced more than 15 persons to life imprisonment till death. And out of that, I think around 9 or 10 father of the victim. They will not see the light. They here at the end of the day, they will not see the light of hereafter. The remaining life will be there in the person. Yes.
The questions are almost over. Any more questions? Srivastava sir, are you here?
Yes, very much.
Yes, sir. Dr. Srivastava sir, he is a pioneer in the field of pediatry. Our side who is doing the work on child rights issues for last so many years. I request Dr. Srivastava sir for your comments and queries, please.
You know, these are very complex issues, and the societal issues are very different. But the important thing is that now these matters are being discussed, they're brought out in the open. So unless you make it transparent and make people know that these are common things and can be, culprits can be anybody, your close friends, your close relatives, and so on. So I think prevention is extremely important. And for this, people have to know that prevention is important, and child has to be protected. And somehow the primary immediate protection is by the parents. Parents should know that these things are possible. They should never leave a girl child alone, even with their neighbors or friends, or whenever the child complains of anything, they must not ignore it. They must listen to the child and they must take it seriously. Some of these things are very well known, but again, I'm repeating this, that all these issues are to be brought out in the open and discussed freely among all the people, professional doctors, lawyers, and so on, by the all civil society. These are not individual matters. And it's very satisfying in many ways that somebody like Nizar Ahmad Saab has been talking about this in great details. These are complex issues. Examination. These are difficult.
Thank you, sir.
Thank you.
Sir, okay, sir. One doubt from my side.
Okay.
Because I was working with the POXO for a pretty long time. What do you find as the difference between the women and child department guidelines with me? I don't have a guideline from the state. Have you find any significant difference, or if any reason why there is two different guidelines?
No, actually it is not different. Actually, it is issued by state government as contemplated under section 39 of the POXO Act. 39 prescribes the state government to issue guidelines. It was issued by after getting consultation, after getting small discussion with all the stakeholders, including doctors. Very detailed it is written. But unfortunately, it is not available. Even you search in the department's website or anywhere, you cannot find it.
No, I tried to get it. What I get is the copy of the certificate, the 10-page certificate.
Only yes, I get only a photocopy. And for your information, I would like to say that during COVID period, I had written a book on POXO Act. It is going to be published on January as permitted by the Honorable High Court. And while preparing that, I only told you that when a case came before the Honorable High Court, the judge happened to see these guidelines somebody produced for the court, and that there is several duties are given to the legal service authority, that is providing legal aid, compensation, and also that is there in the. So the judge called me and shown this. Have you seen these guidelines? Only that. Still, it is a photocopy. I tried to the department to get me to a soft copy so that it can be included in the book. Now I directed my printer to type all these things, these 75 pages, and to add that book.
The Government of India guideline is available in the website.
Yes, this is some very, very. I think this is more than very elaborate, and it depends by taking consideration of the situation in Kerala.
Yeah, I was I was told by somebody that there is a guideline from the state,
yes,
but I couldn't get it. That is why when you mentioned about that, so I would also like you to try to get one of that.
Maybe because it was published by the GO was produced
Home Department.
No, Social Justice Department.
Social Justice.
Later, the department is bifurcated by giving Women and Child Department and Social Justice Department. Now it comes under the Women and Child Department, not on the Social Justice Department. So that is somewhere missed. And when I contact the department, Dr. Anubama, and they are also in search of that, where actually it is gone. Still searching. They are retyping this on the photocopy and updating because of the recent amendments. And you know, there is recent 2020 POXO rules has come with some changes, and there also it is clearly mentioned the duties of doctor, medical examination, etc. Some details are there. So it has to be. The department is taking steps to update this and to reissue the guidelines. That is a position now.
Okay, sir. Okay, sir. Thank you very much for being with us for such a long time.
One question, please.
Okay.
What about the possibility of misuse of the provisions of the Act?
I started my word that can the doctor point out any law in the land which is free from the voice of misuse? There is no law. Even the IPC is being misused. But I can say, I already told you that in contested cases, I can say that 99.9 cases are true genuine cases. And one case I found that I already told you that a case of a lover, that was because of the pressure from the family, she happened to give the name of that lover. Apart from that, I didn't see any misuse in that sense. In the case of, you says that misuse, one case I have pointed out to you that while I was working at Trishur, on one day, I happened to got the charge of this POXO court one day because that judge was leave. At about 4:45 p.m., a boy was brought under the POXO Act. This is just after leaving the POXO court at Ernakulam. So I had the experience. On reading the FIR itself, I found that this is because of the pressure from the family of this man has been booked because they are in love. The family of this girl wants to somehow see that this relationship break out and this boy goes away. And the allegation is that this boy has caught the hand of that girl. Can you imagine? Catching the hand of a girl. It has brought under section 7-8 of the book. Can be police officer.
With intention. With intention.
Yes, because the pressure from the family, they want to see that somehow this relationship breaks. And on reading itself, I found it's false. This is only for that purpose. And usually, I was staying in Ernakulam even at that time. For family was staying here. I used to travel by train in the evening at 5:15. There was a train. I was about to leave the court at that time. It is born. But when I read this, I decided it is not fair to send this man to the jail. I decided that he will be released at any rate. This God has the power. Prosecutor was very much opposing. I told her that even if you oppose, I can be, because this is not meant for this act is not meant for this. If you put that boy inside the jail, there ends his life. So I managed to give that person on bail on that date of, and I advised him, don't try to contact the lady before she attains the age of 18. After 18, of course, you can. If you try to contact again, you will be booked in this case, and also another case will come. So that such case of misuse, that is the only 2 cases of misuse I have seen in my career as a judge.
Okay,
Actually,
sir.
actually, there is a provision for punishing for false allegations, except
Yes,
except the child. Anybody can be, except the child.
Yes,
Others
that
can be
also,
punished for that.
Yes, doctor has studied FOXO better than me, I think.
No, he's a lawyer also.
You know, the section 21. Section 21, there is a total ban of even prosecuting a child. Of course, section 19 points even the child. You can see that even the child is bound to report. But if the child fails to report, even the child cannot be prosecuted. But in the case of false complaint, you can section 23 portion says child can be prosecuted but cannot be punished. There lies the
Cannot be
problem.
punished.
Cannot be punished.
Yeah.
Because that even as God cannot punish because the child being 18 years, less than 18 years, will be tried under JJ Act. JJ Act, you know, General Justice Act. There is no actually not trial, it's only an inquiry in the JJ board. So there is no question of conviction even otherwise. But the statute itself prohibits conviction of the child. But this difference is in the case of the false case, the child can be prosecuted because there is an offense. There is an offense in the case it is more serious than the non-reporting. That is why such a provision is child can be prosecuted but cannot be punished.
Yeah.
Okay,
But
okay.
the parents can be punished. Those who are bringing
Definitely,
it out.
that is another aspect. The parents may not be knowing whether the child is telling the truth or not. There are instances.
That is also there.
Okay,
That's
sir.
problem.
We have given one and a half hours of your side.
Ashok, one more thing I would like to say. If you people are interested, I am ready to take the class a whole day. By the section wise, I can give the detail. It is not possible to take class in such
Yeah, I know it, sir. We are also.
I'm also. I don't know whether Ashok Kumar was invited me just 2 years back in a program at Kannur. I don't know who the person is regarding the doctors. One conference I was invited, but at that time I was not in a position to attend because I have to get the permission of the High Court. Now I am holding the charge of the Secretary of the Kerala State Legal Services. This is my duty to conduct awareness classes and all. So I can come and I can take class also. If you are interested, I will come. Okay.
I think we have met earlier, I think. Probably were you there for Bashir's children's marriage? Justice Bashir?
Yeah, Justice Bashir married, I don't know. Bashir.
At Kannur?
No, there I know. I came to Talasheri in a marriage of my classmate, Advocate Sadiq.
And then Bashir, that was at Kannur, actually.
No, I didn't attend that meeting.
But somehow your face seems to be familiar.
No.
Now, all these people are my friend, you know, Bashir, Andy, Dominic, and Kurian Joseph.
Oh, okay, well, Joseph.
Actually, because I have a PG qualification in medical law, so they used to consult me also.
Okay.
Like that.
Okay, that's why.
Yeah. From National Law School.
So you
are we are taking classes. We are doing training programs for doctors as a part of our ICAP.
You have got a better faculty than me in US.
I just wanted. I think as a Kelsa secretary, we want to work together in the future and the child rights, and we are looking forward to your help also.
Definitely, we can have. Definitely.
Okay. Shall we wind up?
Yeah. Anyhow, it was a very good talk, very informative.